the court finds, correctly as it did, the decision of the Minister of Urban and Rural Development to selectively implement Section 97 of the Electoral Act as unconstitutional and inconsistent with the law. It of course also goes and says that there is a question about separation of powers and that a parliamentary law made and assented by the president that became law could not be unilaterally altered by a member of the executive without the parliament again making such changes. This is the long and short of it. But what is interesting of the same court is that it goes and gives an order of invalidity because it recognizes that the 2014 elections were also done using the same system of EVMs without a verifiable paper trail, and recognizes therefore that its finding of that provision of the government notice basically setting aside the full provision of Section 97 is unconstitutional. Making that finding creates, of course, in the mind of the court a difficulty that the actions taken by the government from 2014 up until 21st March 2020 could also be equally invalid. It's an important decision, it's an important consequence. But they sort of go back quickly to back up that order and says, no, 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 those matters are not affected. In other words, the work of the government elected from 2014 is not invalid. It makes that order. It then says that they make a further order prospectively that those elected in the 2019 elections have also been generated through the very same process of an EVM without a verifiable paper trail. So it recognizes two elections are done without what the law would fully require, the verifiable paper trail. And it says that please make sure that you go and change this, and gives a prospective order of invalidity. In other words, if you don't change this provision that you have made as minister, what will eventually be done by the government would be invalid from the 20th of March or from the 21st of March 2020. That is what it says. Now, one must of course concede and congratulate the applicants for having succeeded in the Supreme Court overruling the Maletsky judgment. The Maletsky judgment was brought to court on an urgent basis before the 2014 elections, as you know. In that instance, for some reason, the High Court ruled that the use of EVMs without verifiable paper trail was legal and that the ECN could proceed in that accordance. This court yesterday overruled the Maletsky decision and says it was unconstitutional that EVMs could be used without verifiable paper trail. Now here comes the question of moral courage. And here comes our suggestion, as we've always made, which is evidence now, that the Supreme Court, as representative of the judiciary, and in fact the entire judiciary, is but a captured system of the deep state that represents Swartbooi and the elite setup, and was never going to order the setting aside of the presidential elections. We said it. That is why when we had our discussions around how the elections were rigged, we said that we are not going to the same Swartbooi courts because they will never, in the fundamental issues of setting aside elections, they will never disappoint the masters who they serve. the Supreme Court and the judiciary, with a few exceptions, are supremely loyal to those that feed them, that pay their water bills, that hire their wives also as judges of the courts, that may also end up promoting their wives as judges into the Supreme Court at some stage, with few exceptions. So let us get back to some of the factual issues. Our view first is that the Supreme Court erred in fact and in law. What are the facts that we are complaining about here and stating? The Supreme Court says that the applicants did not in time raise the issue of the irregularities as they have done in this case. The Supreme Court further says that the applicants were basically relaxing and never took up the issue of EVMs without VVPAT to be used with the ECN. And that the applicants sort of waited until the 24th of October to start to complain about the matter. Nothing could be further from the truth. Even when the Landless People's Movement was registered in February, we, together with all other political parties, still in February 2019, began to take up the issue of EVMs that are being used without VVPAT consistently and conscientiously. The meetings were so hot, disorderly, and terrible that they would often end up in a disarray with people walking out. Because at all of the meetings that we attended as political parties, the ECN was very clear that come hell or high water, they will use EVMs without a VVPAT. They made it very clear. It appears that the court says that the ECN was going to consult stakeholders to see how VVPAT will be used and so on. ECN does not consult stakeholders. Those of us that have attended stakeholder meetings know. Ivan Schreiber is here. Joy is here. Paul is here. Other colleagues are here. ECN informs stakeholders of what ECN wants to do, and that stakeholder meeting was turned into the dictatorship of the ECN on rules, processes, procedures, and legalities as to how the elections should be run. We recall that the meetings were so intense that the ECN eventually gave a report to all political parties at one of those meetings, sometime in June, July, that said something to this effect, and I'm paraphrasing, that they, having consulted the Indian manufacturers that would produce the VVPAT, found first that the Indians are saying that they are occupied with the Indian elections and they just cannot take an order to produce the VVPAT. First. Second, that in the case that VVPATs would be used, they said that as it relates to India, the VVPAT creates a variation of 5% of the total election results. In other words, there is a 5% of the total votes in India that becomes problematic to either reconcile, because the variable of that 5% means that there are difficulties that arise in the eventual counting of the votes. They collated that figure and found ECN, without anyone else objectively being permitted to look at the veracity of their claims that they are canvassing, and to, again, with an independent eye, agree whether it is truthful what ECN is saying. We were presented with the following: that the 5% variation of the VVPAT translated into Namibia's perspective means that we will have a 25% variation of the results. And that the 25% variation of the result would affect about 250 to 300 polling stations. And that variation would be a material consequence on the outcome of the elections. And therefore the ECN was strongly against the use of VVPAT from the word go. So what am I saying? I'm saying two things. First, when they decided to use the VVPAT technology, the ECN and all other stakeholders before the formation of LPM never did a due diligence to understand if it is true what ECN is saying about the variation that the VVPATs cause. And only ex post facto recognized that there is a variation within the VVPAT that could materially affect the outcome of elections. And that is why ECN has been refusing, in our assessment, to actually use VVPATs. When ECN pretends to say that they want to use VVPATs, they want to comply with the law, they are not honest, because they have said that introducing the VVPAT would create problems in our electoral system. And they should be able to come out and clearly explain to the people of this country that given that variation that they spoke about themselves to us as stakeholders, that we should perhaps move away from EVMs themselves and bring in another technology. You don't hear the ECN saying that there is a problem with the VVPAT, that it has a material consequence negativing the outcome of elections. They don't say it. Beyond that, it is very interesting that the court, a quo, has a responsibility to hear the position of both applicants and respondents, and is asked, amongst others, in the applicant's prayers, to make a determination to find Section 97 and the manner in which Section 97 has been implemented, to make a determination that that process is unconstitutional. It is what the court is asked. Make a determination that the application of Section 97 is unconstitutional. It follows, therefore, that the trier of fact, which is the court of quo, must, having heard all parties, make a determination on that matter. And in this instance, it did. The court made a determination in the affirmative that the applicant's prayer is justified, that the manner in which the ministers selectively suspended as a whole subsection 3 and subsection 4 of Section 97 of the Electoral Act was unconstitutional. It makes that finding. And then it does that on an objective process, as the court should. But here is the interesting part. The court, after finding objectively that the actions of the ECN, having used a process of illegality and unconstitutionality, objectively, the court then goes into a subjective inquiry and says, however, the ECN in its mind was of the view that it operated legally and constitutionally. So as the court says, if you are in a criminal case, the court says, I find that you killed the person. You are guilty of having killed the person. It was wrong for you to kill the person. But I think you did not know, nor did you think that you're killing that person. Now what is that? How do you find the process through which the elections are run unconstitutional, objectively, and then you go into a subjective inquiry into the mind of the ECN and say, according to the ECN, they did not think that they were acting unconstitutionally. Therefore, we can't order a rerun. What type of application of the law is that? It's wrong. Once you are to make a determination, and you make a determination in the affirmative that there was an unconstitutionality, the actions of any other party that partook in that unconstitutionality become unconstitutional themselves, regardless of whether the person objectively thought their actions were constitutional. Regardless of that. That's precisely what the courts, as an independent arbitrator of fact, must determine. I think I'm acting within the law as ECN. Applicants feel you are acting outside the scope of the law. You go, because the two of you are arguing, to an independent arbitrator, which is the trier of fact, the court. When the court says you are correct, applicants, how does the court then select the respondent and vindicates the respondents after finding that the actions of the respondent and the minister are unconstitutional? This is the contrast and the contradiction of this matter. And it's actually a Zimbabweanization of the court system. In Zimbabwe, the judiciary has decided that, as a matter of fact, they will never find anything wrong with the government of Zimbabwe and ZANU-PF. Anything wrong. They would then, having taken that principled decision, find all applications to the courts as either without the technical requirements or outside the legal provisions. What are we saying? This is what the courts do when they're part of the deep state. They take a fundamental decision never to disturb their allies as part of the deep state. Then they go and find the reasons for this decision. They don't work through the facts. They have already taken the decision. They then find the legal reasons why their decision to support Swartbooi and the government must stand. And we saw it already when Geingob was making the cabinet statement on Tuesday. We knew this man has been well briefed when he was saying, I will be president, I will be sworn in. We knew, and they had a party. There was a picture of him apparently tipping or babalas or something, drinking, because he knew that there was not going to be a rerun. So what am I saying? Let me focus. Court finds that the manner in which the elections are run, in other words, EVMs without VVPAT, and the determination, therefore, by the minister to allow that process of EVMs to be used without VVPATs, the changes he made to Section 3 or to suspend Section 3, subsection 3 and subsection 4 are unconstitutional. That's what the court finds. It therefore also overturns the decision of the High Court in Maletsky. That's what the court has done. So in that regard, there has been success recorded. That is very good. But it also is an obvious thing, really. It's an obvious thing. Nobody needed to go to court to recognize there is separation of powers. Nobody needed to go. But what has happened? And these are some of the parliamentary agenda points that we'll take. When a parliament begins to believe that it reports to the executive, you have a problem of this sort. And we spoke to Kachevive about it sometime, where the Parliament of the Republic of Namibia, in making laws, grants excessive discretionary powers to administrative officials, to the point that Parliament itself derelicts from its duty and its oversight function. In other words, the parliamentary laws since probably around 98, 99 begin to sound something of this sort. That the executive director must, in his opinion, do ABC as he deems fit, as they consider appropriate. That type of broad discretionary power given to administrative officials creates excessive powers that reduces the capacity and the legal responsibility of Parliament to check and balance the executive and its work. And so as LPM, we're going to fight very hard for the drafting of laws to allow Parliament in such a way to be able to exercise decisive oversight function. What you have is a parliamentary abdication that allowed a minister to change and implement a law as he deems fit, but even on an essential and central issue of suffrage. Yes, ministers are allowed to implement acts from time to time in parts and pieces, but not on an issue as fundamental to our democracy as elections. But you also see here that the apartheid judicial approach is fully alive in this country. Fully alive. What am I talking about? Apartheid judges were judges for the apartheid system. Judges in this country, with few exceptions, under Swartbooi government, are judges for and of Swartbooi government. When this guy, Shivute, started, and he's a nice guy, when he started with the articulation of the case, it was so beautiful. So beautiful. And then he just turned it around. Normally, a judgment where you make a determination on the core issue and you arrive at a determination as he did, that this process was unconstitutional, must also accord with the order of court here. But you find the entire process of elections unconstitutional and you allow the president to be sworn in on the basis of an unconstitutional process that you made a finding of. This is the contrast and the contradiction. I wish this man could have more coffee with Mogoeng. It is bad jurisprudence. It is bad public policy. Because what has happened here is that the ECN is celebrating. I don't know why they should celebrate, but they think they must be celebrating. Why? Because the ECN is told everything that you have been doing is unconstitutional. That's what they are told since 2014. Yes. Everything that you have done since 2014 is unconstitutional. That's what the court says. Everything you have done in 2019 is unconstitutional. It's only that you thought that you were acting within the law. That's what they are told. And then he says, oh, by the way, the statements by Rao, the Indian hacker, that's a very good one. It was not contested by anyone. Rao is our friend, very good friend, who came in without a arrival permit and all other things. Rao, he had a statement again in the Supreme Court, which the judiciary took as part of their decision that the ECN submitted. So colleagues, as I'm finishing, we have a very bad decision where the judiciary decided, as we predicted, that they sided with the deep state and through their own process of lawmaking confirmed Gengop as the president. But if I were Gengop and others, I would be a bit worried also about this decision. Because it says, 2014, unconstitutional, unverified. 2019, unconstitutional, unverified. But go ahead, be inaugurated. By the way, fellows, we are validating all the actions of 2014 up until 20 March 2020. So the decisions you took, the decision to grant fishing rights to Summer Ridge and others, all of those decisions are valid. Parliamentary acts that were passed are valid. Appointment of Swartbooi and others are valid. This is what the court said. But the election, the process, all of that, unconstitutional. Now, the problem is that the court yet again leaves the process of managing the elections in the hands of a constitutional thugs by its own finding. I'm paraphrasing there. That they will now have to go and change the act to bring back all the requirements. Subsection 3 and subsection 4. What is the problem that we see here? They will probably comply yesterday with that part to get through, get inaugurated, and bring a bill this time to just change it, as was the case that was ruled unconstitutional using Parliament now. That's all they will do. In other words, when the minister's decision to suspend the part that says EVM should be used with simultaneous verifiable paper trail, those parts that are suspended, they will just, by law, through an act of Parliament, suspend those ones now. They will not use the minister. They will now use Parliament to vote on it. And we are, of course, going to be fighting on that issue because the system must change. There is another matter that the court did not fully express itself, and that is, does the voter who goes and votes have the capacity through a capable system to be able to see where he or she cast their vote? That was one of the attacks by Gauntlet. Can you see where you voted? If you have a paper trail, you vote at LPM as more than 300,000 people did, but you check whether you voted there, you fold the piece of paper and you throw it in. EVM doesn't allow it. They don't allow it. The court tactically was silent on that point. They were silent on that point. Why? Why? They were talking in generalities about the EVMs. Why are they quiet on that point? Because the court did not give any proper direction except to say, do this, do that, and so on. Now, what is the problem of these EVMs? How do you, and this is how the ECN as part of the structure of the executive created to continue to deliver victories for Swartbooi operates. Stakeholders get together, they say we need to move away from paper trail. They agree that in moving away from paper trail, we need a different system. It is introduced in Parliament. It is promulgated, assented, promulgated. Then ECN goes and buys a system without the VVPAT, unlike the initial agreement with other stakeholders, and comes back, the minister suspends now. Can you trust the ECN, which in this instance became the principal advisor to the minister? That is one. Number two, can the court convincingly say that it is fair that you raise the stakes for the appellants and reduce the burden on an institution of state? The court says, you appellants, you were sitting idle. You should have taken this matter up early. You should have done certain things to fight against just from 24th